All right. While we're waiting for other people to join, right to roll over to 10 o'clock, just really quickly, Sheila is our Region 1 director.
Yes, ma'am.
So she services West Texas, which, as you guys know, is a gigantic area. And we are so grateful that you guys are here for training. We do this because we know that it's hard to get to the bigger cities to do the training. So we want to be able to bring you education that y'all are interested in. So if at any point you go, gosh, I wish I had more knowledge on this, please reach out to either Sheila or myself, so that we can get speakers to talk to you about those topics, because I bet you're not the only person that has that question. We do have a in-person training coming up in Canyon, Texas. It's going to be in Sheila's neck of the woods. That's about 3.5 hours north of Midland and what, an hour-ish outside of Amarillo.
Oh, from Amarillo, well, it's 12 miles. So I don't know. It's probably about 25 minutes.
Oh, not even an hour.
Yeah.
So we're gonna have Pat Riffle coming out to talk to us about youth diversion and court costs. And if you or anyone is interested in testing, they'll be able to do that afternoon of July 11th. So keep an eye out in your email for that. We're very excited about it. We are trying to get education out in the West Texas chapter. So we appreciate you being here. And with that, I am going to kick it over to Ms. Sheila.
All righty. Well, good morning, everybody. Again, I'm sorry if there's any sounds. Like I said, I'm sitting in a hotel room here. So Kirby had a little mishap, and so I said I would step in and do it for him. So this is about appeals, and then also the motion for new trials. So this is after you've gone through all the fun of setting up the bench or the jury trial and summoned your jury, went through the whole process. This is kind of the steps afterwards. So let's see if my computer's gonna, oh, there it goes. It responded up, and I hit too many times. Sorry. So the way I did my presentation, I wasn't sure who was a court of record versus a non-record. So I have included both of the different scenarios in this presentation. So this is for after your judgment. So I'm currently right now a court of non-record. And then in September, the city of Canyon adopted that we turn into a court of record. So I thought, well, it kind of applies to both. Some of them are similar, some of it's a little bit different. Your court of record's a little more judge driven. So they're both in here, both can be used. So this is going to be after, like I said, after your bench and jury trials. This is your judge, depending on what I always say it's their spiel that they give the defendant after the judgment has been determined, whether they're found guilty, they're ruled as guilty in the bench trial. So the motion for the new trial it's a brand new trial, and it's still in the same convicting court. This is not, I want a motion for a new trial, and it's going to go to your county court. This is going to stay in your court. So that the defendant has two rights. They have the option that they can do the motion for a new trial and have it heard again in the court, or they can appeal that and have it heard or reviewed in the higher court. So the same thing applies. I'm trying to get rid of my screen here. The judge has to decide that, justice wasn't served. The defendant needs to be able to, if it's in the court of non-record, I will tell you. So I've seen it in two ways, one from a non-attorney judge and I have an attorney judge. The non-attorney judge would listen to the discussion. I call it a discussion from the pro se defendant on why they felt that they weren't heard properly and they wanted to do it over. That was the non-attorney judge. The attorney judge, my judge now, she would be, okay, you need to make that motion. Here's the paperwork. fill this paperwork out and then you can submit it. I'm going to give you, and she gives them the date in which they have to have that documentation back in. So just a little different between the non-attorney and the attorney. So that being said, if you have that non-attorney judge, depending on what your relationship is, I always like to, for myself, if you're somewhat of a one-man show in your court, I like to, when I go into my trials, I like to have all the options there and ready to go. Like I have the forms already, the dates already, so that way I can just answer it on the fly versus, okay, let me look it up. So I always try to have that ready. Like the mailbox rule, it does apply. A lot of us are probably somewhat paperless. So I always say you got to go back in time and you literally have to order that stamp. If you don't have the machine that you can shove the paper in there and it time stamps it with the date and time of the documents, go get yourself that, ink pad stamp where you can adjust the date and time, and make sure that you're using that on all your documents. My judge does explain the mailbox rule. She's like, it's 10 working days. She explains what that means. So she's like, if it doesn't count Saturday, we're talking working days. Those are your 10 days. She explains this is the date we have to have it in there. And then she also explains the mailbox. When it comes to that mailbox rule, she's like, if it's postmarked by this date, it's timely. And she explains that to the defendant. So I like that. Now the state's not entitled to that new trial. Now they may make a motion. So this did happen to me. They may make a motion to continue the case. So maybe they're missing a police officer that didn't show up and they want to make a motion for a continuance. Now they can make that. My judge denies them just solely on the fact that if everybody was subpoenaed and just kind of that basis. But so the state's not entitled to ask for a new trial, but they can ask for that continuance. So that would be up to the judge before that final ruling gets entered in the judgment if they want to have a continuance. That did happen in a case just actually 2 weeks ago. So the timestamp documents, again, just need to make sure if you don't have that timestamp or the machine, get yourself the little mine's an ink pad, and I gotta adjust it, click it, and stamp it on all those documents. Now I do know some software, if you scan it, it will do some kind of electronic date. I'm not sure how. I'm not that tech savvy, so I'm not sure exactly how that looks when you want to print out those documents, if it actually has that. So if that's the thing you're relying on, you got to kind of make sure that when you're scanning that is something that's going to be captured on the document. So your deadlines for your motion for your new trial, and again, this is split up. So for your non-record, it's a little different. It's 5 days after the date of the judgment. So if your trials are on Friday, they have till next Friday to make that motion for the new trial. The judge has to decide within 10 days. If your judge doesn't make a decision, it's just considered denied. So that kind of makes it a little bit easier on us. So if your judge is, I'll get to it later, and it comes time for that date, it's just denied. It by law, and I put the statutes in there also because on and I can, if you'd like, I can even email those some of those papers we give out. So when I send a defendant, a pro se defendant, on for a bench or a jury trial, we give them a trial handout, and it explains what we expect from them. So if they discovery requests, any motions they want to file, and what those dates kind of look like. They don't have the exact dates because maybe the trial might change it, but it explains what the timeline is for that defendant. And we also have them sign for those documents. So if you're doing something that's through the mail, I like to send everything certified mail, especially only when it comes to those bench or jury trials. If it's a mailbox plea, and they know you're a court of non-record, or maybe it's a CDO and they're like, I'm entering a plea of, no contest and I wanna appeal it. Okay. I send those documents out to them, the return documents out to them in certified mail. So I know that they got all the information that they need to appeal a case. It's the same thing for a motion for a new trial. If we don't do Zoom trials anymore, I just say this in case you still do Zoom trials and stuff like that. I always, at that point, I will always send stuff certified. They get email copies of everything they sign and everything like that. But so yeah, so if there's no decision, then that motion for new trials denied in that court of non-record. Again, timestamp your documents. It's really important. If the motion for the new trial is denied, the defendant can still appeal it. So, because they haven't actually had that new trial. So you got to think about it like that. They asked for one, it was denied, but they didn't have a second trial. So they can still appeal it. In non-records, I don't really see anybody really filing a lot of motions for new trials. Just because we are a court of non-record. Now, I'm assuming that's probably going to change once we're a court of record. But if we have anybody, for us, we have anybody that has a trial, and we just never have them. They just appeal it up. So I have personally have not handled a motion for a new trial. It's always been the appeal process for the court of non-record, because they get a whole new trial. So, but now your court of record, that's a little different. So that has to be a written. So the non-record, you can make an oral. So if I was a defendant and I was standing, I'm like, no, I want a motion. I want to have a new trial. I don't, this officer wasn't there and I want to have it. Now that's your judge determination, but they can make that orally versus the court of record. That has to be a written motion. 10 days to file with the clerk. Again, can't say enough to timestamp everything. And I say timestamp it because that is one of the things that's going to be asked. If they hire an attorney, that's going to be one of the things that attorney is going to know. What day did you get this? Let me see that time date stamp, or let me see when those records were received. So just saying, well, I scanned it in on this day, that would be something that you would want to ask your prosecutor and your judge, have a discussion with that. Are where do you stand on documenting the paperwork being received into the court? Are you fine with a scanned history of the day that it came in, or do you want it actually stamped before scanned? So I would always just kind of double check with your judge and prosecutor on that type of procedure.
We have a question, Sheila.
Sure.
Becky's asking, are you saying that just a date stamp does not suffice?
Yeah, anything that so like I said, mine's the old ink pad. I adjust the dates and times and I stamp it on every page I receive. Envelopes, everything. So that counts as your timestamp. So you're documenting when you received that and when those documents were filed within your court. So that's perfectly fine. However you want to timestamp it. Some people, there was one clerk a long time ago. I remember she would just write the date and time and 2 clerks would sign it. That's acknowledging, you have 2 parties acknowledging you received it. It's however your judge and prosecutor are reading and standing by, documenting that their court received the documents. So because they're the ones that are going to be essentially the judge for your court of record, they're going to be reviewing all the documents and they're going to, and if they're missing a timestamp on there, well, when was this paper received? Was it timely? And then if you're looking and going, well, I must have forgot that. So those are things, for myself as a clerk, I never want to make a mistake. I would rather have somebody else like the judge or the prosecutor make that mistake. So I try to find all the ways that kind of takes me off of that little chopping block a little bit. If I have a system like in Amarillo, when I worked in Amarillo, we literally had a machine and you'd stand there, clink, 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 and it was a loud machine. And we timestamped every one of those letters and then we scanned it in. That's how that was done in Amarillo. So, I mean, we would enter it in there and it would clink the date and then scan it. So, Canyon, they didn't have that type of machinery. They didn't really even have the software. So we were just using the shucks or the envelope. So I had the time. So I just never went anywhere else. And I just kept doing the ink pad type stamping. So the mailbox rule does apply. So if you have in your software or if you're still using shucks or whatever, I would strongly notate that mailbox rule. Like I said, I make my judge determine that. So if she forgets or if he would forget, I would just say, Judge, what's your date that they have to have all these documents down? I kind of throw that back on them. So that way they're saying, okay, June 12th is the date you will need to have, have the written motion in, or you're going to have, whatever it is, all these documents back in, or payment by, or appeal by this date. And I notate that date in that docket. So I use the encode software, I put the comment in there, and I also created a status. So if your software allows you to create statuses, for my trials, so if I have a bench trial, I also have, after that bench trial, the judge will explain, okay, you have this long to make a motion for a new trial. I have statuses. So it's going to be, my status is MN, so motion for new trial, and it generates that date, appeal, and that date. So I have two statuses, or I'm not sure what kind of software, but I have two different statuses for the bench and the jury trials. So I know that if they want to make that motion for the new trial, it's going to be this date. So on this date, they haven't made that motion, that date and time has passed, that status will move down, the new status will move up. So now they have this date to appeal it. So, and their documents that I'm giving them that information. Your date for a motion for a new trial is this date. Your date for an appeal to have it completely reviewed is this date. So that way my defendant is fully aware of the days in which they need to have it. So, because a lot of people don't understand what is the, timestamp rule. A defendant's not going to know what the timestamp. So it's easier just to say, you need to have this motion for a new trial by this date. If you do not submit it, or we have received it by this date, then you can then appeal it, and this is your date. And so that's what I give out to them, and that's what I do in my software. And it also makes it easier too in the software, especially if you have a lot of trials. I was speaking to a lady just yesterday, and they have like 2,000 jury trials that they're setting. So those are a lot of trials to keep track of. And if they schedule, I think she was saying they're going to try and schedule like 40 a day. I mean, that's a lot. So that's a lot of paperwork. So I would much rather my system do that for me. And they're just like in like a queue where I have to work the queue going, oh, okay, nope, they didn't make that motion for the new trial. They're out of this queue. So yeah, do whatever it is that makes your job easier. So the contents for the new trial for your non-record, so they can have a completely new trial. So if the motion's granted, they get a completely new trial. It just happens all over again. So the defendant, they only have one. So if there's no response on that motion, then they can still appeal it, and they can still get that second new trial, but only one. If the motion's granted, that's all they get. They can't appeal it. And then, so this is where I added some of what I do. So I want that new trial to happen as soon as possible. And the only reason like that is, number one, it's a timely process for the defendant. So we have that right to that speedy trial. So this is going to give them, I'm going to have several dates and times ready. And I will, prior to going in, I always double check with my prosecutor. I have a remote prosecutor, so he's not on full time. Now my judge is full time, but my prosecutor's not. So prior to that bench or jury trial date, I gave them 3 dates and times. Okay, if this happens, here are my 3 dates and times. Can you check your calendars and make sure these are good dates? And then I already have that before I'm walking in, so I know I can say, Judge, we have this time, you know, May 2nd at 3 o'clock, May 5th at this time. And so then the defendant can look on their phones. My judge will allow them, if you want to look at your phone, see if that date works, and then it's already scheduled. So we have a tentative, I have a tentative new trial on this date. So, and again, state's not entitled to a new trial. They can hear that motion for a continuance. The same document. So it's pretty easy on the court of non-record. Same documents are used. So I do this great thing, just keep them together. You know, if you printed out everything, all of that fun stuff, I just keep it all together in the folder. If that motion's granted, you use the same folder. The only thing you're going to have to do as a clerk is create a new judgment. So, you know, if you're swabby with the macros and stuff like that, if you have in code and it can generate a new judgment with that court date on it, then you've already put that in your folder and you're ready to go that day, and you don't have to stress out about what you need for your new trial now. That's going to happen. So I try to do as many things as I can to make the day of the trials not so stressful on myself. Now, they get a new trial, they don't get a new complaint. A new complaint's not filed. So there's not an amendment to the complaint. There's not anything. It's exactly the documents all over again. So, and any new evidence or anything, that's not anything we have to worry about. That's all during the trial, and that's the prosecutor and the judge's job. It's not anything we have to worry about. If what we submitted, what we gathered together, I don't know about like you, I'm a paralegal pretty much also. So I have to get all the video files, the police officer summoned, the audio and all of that type of stuff. So I have it all in a thumb drive and it's stuck inside the folder too. So that stuff's all done and ready to go. So, and what I included here, so this is the TMCA bench book. And I will tell you, this is the cheat sheet for me. So it's the judge's bench book. It is available online. You can download it. The forms are online. I mean, you can download all of that. And this is what they use because this is their bench book. And this is exactly what I use. And there are step-by-step instructions. So I completely copy what's in their bench book. So, and I love it because it has the statute. And so I can always refer back, well, according to we need to do this. And then, oh yeah, you're right. And so I do that. So is anybody a court of record that's on here? Just Zeta? Everybody else is non-record? Oh, is there one more person?
Jackie.
Oh, okay. I only see 4 people on my screen. So that's what, okay. So for your court of record, for this motion for the new trial, so it has to be filed. So the court of record, we're going to do the filing. So you have 10 days after the date of the judgment is rendered. So again, same process that we're going to do for we're going to do for the court of record. Judge is going to give them a date, the date in which they need to have those motions filed. We give them an instruction sheet as well. And see, so the motion, so we, as clerks, we have to make sure, so this is a good point. The motion includes points of error that has to be brought up in their motion for the court of non-record. And it has the general code that needs to be in there. This is where, as a clerk, we all have to be very careful that we are not giving out any legal advice. So that's where I strongly say, get a trial packet together. Get your motion for a trial, get your appeal process, get that packet all together, have that reviewed by your prosecutor, have that reviewed by your judge, and have them swear off on that. And that is the only documentation that you as a clerk are going to give out, and you are not finding yourself in this situation where you're giving them the legal advice. And that's something that we cannot do. And so That being said, I mean, they have to bring up those points of error. That's going to be on them to do that research. It's not anything that we can help them with. The only thing that we can truly tell them is, okay, you need to have this filed by this date. Here's your packet, do it by this date. And make sure everything's timestamped when it comes through. So again, it can amend the motion. So if they file that motion, they can amend it if they feel like maybe the defendant, he left something out. He can amend that no later than 20 days after he filed the original motion. So he has 10 days to get that in. And then if he wants to amend it, he has to do that no later than the 20, because the court has the 30 days to review that motion. And if they don't, then it's overruled just by law. If they have not responded in that 30 days, the judge has not made a decision, it's overruled. So they don't get that new trial. Now the judge, that if you have a defendant walk in and went, you know, I need to get an extension. I need to amend it, but I need more time. That defendant has to go in. So that process, so that's why I kind of put this out there. So you need to know, how does your judge want a separate docket to hear any type of motions for a pro se defendant? You know, do you want a separate docket, you know, judge, to hear any type of motions that need to be heard from a pro se defendant on making that motion for the new trial, or if they need more time, what kind of a docket do you want set? And you know, and so that way it's not anything you have to worry about giving out to the defendant, but you know, if they come in, or what kind of docket you're going to put them on, and then also get whatever kind of a judgment or a cover, we call them docket sheets, the docket sheet that judge wants to have. What information does that judge want to have if they're going to hear a motion to amend that initial motion for the new trial? What documentation do they want? Or they, and that would also be, your prosecutor's going to need to be available as well. So that's just for your courts of record. That might be just like a side note, you know, what type of docket setting or when and where does that need to be set? What does that status look like? What does the walk-in, what does your paperwork need to look like for you to review that motion to amend the initial filing? So any questions before I keep going? We good? Okay. Any comments? My good, bad, ugly? Okay. All right. So I included jailhouse pleas. I'm not sure how many other people's courts are doing jailhouse pleas, or, you know, your magistrate, whatever you want to call them, video magistrates, your judge likes to go into the jail, you know, whatever that may be. So this slide here, I had my judge actually do this slide, because I call it her spiel. So she has a spiel that she always gives to every person that she sees on when she magistrates them, if they're in jail, like the public intox or the, you know, family violence. So she has this little spiel that she does. And also, if it's someone sitting in there in jail and they have warrants with us, she'll ask to have them pulled up, and then she'll talk to them. So they can take the plea from jail. And it's a 10-day rule. So they can enter that plea of guilty or no contest while they're in jail. And so what's in yellow is what she tells them. And so I don't know if any of your judges do it. You know, this is a good spiel for them to say, you know, this might help when the defendants come out and they want to change their mind. Judge, we could set them, if you're releasing them the next day, or, you know, whatever that date is that they're coming in. You know, do you want it to be 10 days after they've pled in jail, or you PR bond them for the next day? So when they come in the next day, we're going to have them actually sign that plea and you know, acknowledge it that way. And that's exactly our process. So she'll take the plea, and then she'll tell them, okay, you have 10 days. So if they're still sitting in jail, and so this is something, this is also, again, this is kind of where my statuses come into play. I can enter that plea that was made in jail. That's perfectly fine. They did they're sitting out higher charges. So, or they have to come up with a $10,000 bond. So we know they're gonna be in there for a while. And they're like, well, I'll just plead no contest, and then I'll just want to set up a payment plan for whatever I owe. Okay, great. So I have a status for jail. I have the date that they pled, how they pled, and then I have another status that's 10 days. Because if they say, well, I'm sitting in here, I'm trying to, I have to get a bond for X amount. Okay, well, they have 10 days from when they're released. So I keep in contact with the jail. So I might have the jail release in the plea that what we sent, but then I also make a note, or it's a status, that in 5 days, that's going to pop in a queue for me to look at again to verify with the jail that they were released. Especially if I haven't received the PR bond signed back or cash bond, whatever it is, if I have no documentations in 5 days, I'm calling the jail to find out where they're at, where that defendant's at. Because if that defendant was released, and that goes from the day that they're released, they have that 10 days. So if they were released, 3 days after we were seen, and now it's 15 days, for whatever reason, I've kept calling, no, he's still in there. Maybe I go on vacation. He still hasn't appeared. Now we're going to have to summons him because now he forfeited on that appearance bond, but his time to make that motion has now gone because he was released. So that's where that release date's really important, because it's whenever they're released, they have that 10 days. And so the judge doesn't go in big detail with that. That's just something as me keeping my court records, is I'm just very mindful of I want from the jail a copy of those release. So I get a jail booking and a jail release every day. And so that's just something we kind of have to, as a clerk, just kind of be aware of when they actually were released. Motions after the jailhouse, they have to be granted, and she tells them that. Mailbox rule applies. And so she'll tell them, if you make a motion, and she'll say, even if you're in the jail and you want to change your plea to not guilty, because maybe you met with your court-appointed attorney and it's a DWI case, and that attorney doesn't want you to enter that plea, you have the right, you can ask your jailer to get in contact with the court, and I will hear your motion in jail. So she explains that to them. So, and this talks about the jailhouse plea. So that the statute up there. So ask your judge if you're not part of those jail proceedings. Ask your judge, or what the process is, if this is the same process or if you want to change it differently or something, and especially with your jail. If you don't get information from your jail, you're just one of maybe your jail's in another county and they mail everything. If you're not getting that updated information, whether it's daily or weekly or however they do out their reports, that is something that you need to figure out a better process and get in communication with your jail on release dates and stuff like that. So, and I will tell you this, so Judge Cates is my judge. I will tell you, she'll be more than happy to talk to any of your judges, if non-attorney or if they are attorney judges and they want to kind of, if she has some forms and stuff, she'll gladly share those with you. So, and she'll talk about the jail. She does a lot of jail magistrates and stuff like that. So, okay, so those were your motions. That's your jailhouse. Now we go on to the appeals. And appeals, I think, I'll be honest with you, I truly feel like they're the easiest things that as clerks that we probably get to do in our job, because this is just simply paper pushing. So the appeal, there's several things that come out of that. Again, I put down there, just make sure that we're not giving out legal advice, even to the attorneys. we'll have attorney, I have attorneys that'll call, like, they represent the CDL drivers. And some of the times they're like at a completely, like, I have one that called from Oklahoma, another one that was out in Nevada, and they're like, well, I need you to tell me, how am I supposed to appeal this? Like, what forms do you need from me? This and that. And I can't, I can send you the appeal sheet, the checklist that we have, and that's going to tell you what everything that we need from the court. Or from you, so that we can process it. That's about all I can send out to you. Well, yeah, I need to know, but you need a motion for this and a motion for that. Sir, I'm not an attorney. I can't answer that for you. I'm just going to send you my checklist. That's what I'm gonna do. But if you'd like more legal information, I'll gladly let you talk to our city attorney. And then I just end it that way. So just be real mindful. Those attorneys will try and ask those questions too. So a big thing that I put in black is written judgment. So we have to have that written judgment. So it can't be, well, you're found guilty. You have this day to submit for a motion. You have this day to submit for an appeal. All right. Well, if we don't hear from you, then we expect payment in full, and then they'll walk out. You need something in writing. You need that signed plea. You need a signed judgment. You need that. That needs to be included in your appeal paperwork. So, so just make sure your judge actually completes a judgment, whether it's on, he's handwriting that and checking boxes, or it's a macro that he's running on a computer screen. They need the judgment on there. So that is something that has to be done by your judge on that time. So the appeal for your non-records, it's a completely new trial. It's just a new day, new walk in the park. And somebody gets to hear your story again. You get to step up and you can tell your story, and somebody else is going to judge it. Your court of records, all they're going to be reviewing is the facts of the case, what the facts are. That's it. And that's why I kind of feel like the appeals are probably the easiest part, because all you're doing is just getting all the paperwork together and you're just sending it on over. There's not anything else that, you kind of really need to do, because everything falls on your judge at one point. So a direct appeal. And so this is going to be a lot for your court of non-records, especially if that attorney knows and understands that a court of non-record, that's just a whole new, that's a trial de novo. That's a whole brand new trial. So you might just get a rep letter and saying, we enter a plea of guilty and we're appealing that. Okay, well, that was your trial, and now they want a new one in a higher court. Or it's just the defendant. They can do the exact same thing. But now all you're doing is just sending over just that mail and that couple of documents, and then the higher court's going to review it. So like I said, their appeals are like a simple thing, and you can find yourself getting overwhelmed because you think that there's a lot more for you as a clerk to do. And the great thing about it, this is probably the process where it's just you get everything together and you just pass it over. So let me see if this is gonna let me move to a new screen. There we go. Okay. Is everybody hear me okay? This one says I have low audio. Okay. I keep getting a pop-up on my screen. All right, so your appeal bonds. So I started first with the appeal bonds. So your non-record, now the bond can be 2 times your like the fine and court costs. So we make simple numbers. Fine and court costs, it comes out, the total is 200. So the judge can say, okay, your bond will be $400. It's just double the fine and court costs. So it's now $400. Or your judge can also just say the bond needs to be set at $50. That's your appeal bond. It's $50. It does not state anywhere, nor have I found anywhere where it says that it has to be double the fine and court costs. Your judge can set that at $50. The same thing with the court of record. The judge can set it at $100. And so you know, that might be something mindful of your judge. I mean, you can always ask your judge, because in some systems, it'll allow you, it'll say appeal, it'll say the bond. And it can say a specific amount or double the amount. So I kind of, you know, I had one judge, got a new judge. And so the new judge go through everything. And I was like, all right, on your bonds, do you want it to be double, or do you want it to just be $50? Or do you want it, what number do you want it to be? If anybody needs to, they want to post the bond on the charge. So ours are double, but it can be for the non-record, it can be $50. So that's completely, and that's a determination by the judge. Again, bonds can be cash, surety, or personal bond. But that personal bond has to be approved. The judge has to approve that. It's just not an automatic. The judge will have to grant that personal bond. It has to be filed 10th day after the judgment, if you're appearing in that open court. If it's done by mail, so for non-records, if it's done by mail, they have up to 31 days after receiving that notice. So mailbox, they mail in, then they mail in a plea, and they say that they want to appeal it. Like maybe they're an out-of-state person, you know, whatever that. I have a lot of that because of college. So they have 31 days then to get that appeal back in, based off of it being a mailed plea with the appeal. So again, but that's all, those dates, again, I say it, can't say it enough. Have your judge set that appeal date. And then it falls back on some, you know, on the judge, because they're setting that date and time that stuff needs, well, the date that it needs to appear. Then we go to a court of record. So non-record was 50, your court of record now, it can be $100 appeal bond. Doesn't have to be double. It can be that $100. So again, that might be a question. You ask your judge, are we good with setting it double the fine and court cost to appeal it, or do you want it to be at $100? Still can be the cash surety, personal bond if they want to. Now that bond has to be filed on or before the 10th day. So that's a little different than the non-record. So your court of record, the time's lessened a little bit on the appeal bonds if that's going to be that 10 days. So, and that's on the bonds. Okay, so this is where I was like, all right, so if I'm the clerk and I get frustrated because I have to do all this. So I wanted more of a step-by-step. Again, the bench book, I downloaded the bench book. You can buy the book, whatever you want to do. I downloaded it. Every legislative year, I download the new bench book. Not that the process changes, but we have now 45A. So they didn't just add A to everything. They actually changed all the numbers. So I don't know if anybody's familiar with that, but you know, I thought I could go through and just do A. And then I started looking at the card and I was like, oh, great. They changed the numbers on me too. So, so like I said, I use those bench books. So for your non-record, the appeal, so this is, as a clerk, this is what we're going to do. So we have to make copies. So if you're scanning all your dockets and you're a paperless court, you're going to print out all those documents. You're going to make sure that you have all those case files. That's what's going to be sent to the higher court. You're going to make copies for it. The appeal bond, if it's not filed timely, or it's not even received. So if you're in court, the judge gives the order, says you need to have all this document. The defendant goes, well, I want to appeal this. I'm gonna appeal it. Great. So it's written on the judgment, defendant appealing, it has the date on there. That date comes, you have your packet together. It's notated. They are appealing it. They send an email. I'm still appealing it. I call. I just call and I do reminders and I say I call. It's an automated machine. It just calls and reminds them, hey, you I think it says your parents at court, paperwork is due, and then whatever that date is. And so they get a notification. So if they're in my queue, so those appeal, that person's docket's in my queue to look at. And it's May 1st. I haven't received any of the paperwork. I haven't, well, I've got the notice. I take that back. I got the notice that they want to appeal it, but I don't have the bond. I don't have the money. You still have to send everything. It still gets sent over. So you're taking all that file. So with that, then the judge will put in a letter saying the appeal bond was not perfected. No bond was received. That still has to go over because they appealed it, but it's not your decision to remove that appeal. So that's what I'm saying. This is a rule where you're just literally pushing papers back and forth from one desk to the other. So they can't, so on the non-records, they cannot make a motion to withdraw that appeal. So if they say I'm appealing it, they can't make a motion. It has to go up. If the defendant is convicted, and so some courts have the process, which I kind of was asking different people when I was sitting on one of the clerks saying, some people have a process where they make them pay, the judgment, but they hold the money, and then they send the appeal bond over, and then if it's enrolled in favor of the judgment, then they send back the payment on the original judgment. I don't do that at all. They have this day to appeal it. If they do not appeal it, we send it, it's kicked back. I mean, it's usually on those types, if they don't send the appeal bond and the letter's on there, it goes to the higher court. By the end of the week, it's just coming back. Because it was reviewed and okay, well, they didn't do the appeal bond. So they're convicted, it goes back, and then we can go after them for the judgment of the original amount. We don't take the money and hold it. And I don't know, that's going to be more of a legal question. Are you allowed to do that? I don't think so, but I definitely would maybe get with your prosecutor and your judge. If you're taking the money and holding it, you might want to have that just kind of reviewed a little bit on that case. So I don't do it. A couple other courts were doing it. They just take it and they basically put it in a safe and then they wait. So I don't know. I didn't like doing that. I just felt that was just holding somebody's money, playing the banker. So I didn't like to do that. So, and then, like I said, you'll get that writ of Prociendo back. And that's for the municipal court. And that tells you, the appeal bond, it was filed, it was past the deadline, conviction, upheld, and then it's back in yours. And now you're just trying to collect on your money for your non-record. Okay, so for your court of records, so this rule, so they have the 10 days after, so I included the motion for the overtrial. If they make the motion for the new trial, there's no response, it's been overruled. Now they're gonna set that, they're gonna have that bond that they're gonna need to send in. It can be the $100 or whatever, double the amount, depending on what your judge orders. The mailbox rule does not apply to when the bond's being mailed. So if they're going to mail in the bond, this mailbox rule does not apply. And this is just only in the court of record. The judge they have to approve surety companies if they're going to do it. The judge also has to approve the record that everything has come together. It's basically you, the clerk, are getting all the paperwork together, and the judge is going to approve it. That's all you as the clerk, that's all you have to worry about doing is just getting everything together and giving it to your judge. And so that's where I say, don't ever overthink your role, because your role just basically is just getting all your papers together. The defendant they have 60 days to comply with this. What you're going to send over or what you're going to get together, the judge will review it, but what you're sending your record, any other records that were submitted at court, any materials. And now if there's any transcription, if you have audio and you pay somebody else, if you don't have the court reporter, the defendant's paying for all the costs of all those records. We have that in our ordinance. I probably most courts have it. You might double check your ordinances and make sure that it's in there. If someone's appealing, they pay $25 for that. It's they pay the $25 to the court, to your court, because that is what they're paying for your preparation fee. But they also have to pay for all the costs associated with getting that record together. So if it's an electronic file, and it's a digital recording and you have to pay a transcriptionist, then they're responsible for all of that amount. And prior to that, I mean, you can send it over, however you're, if you have a court reporter, then obviously that's the record that's there. But if you're sending it off, then rule of thumb would be send it off, have them review it, have them give you either an estimate, or if they're going to give you, say, it's going to cost us this much, then that is the amount that has to be paid to get that record. Now, with that being said, you don't order the record until it's paid for, because now that's going to be a court cost that somebody's going to have to pay. That falls on the defendant to pay Jack's Recording to print out that record and do that transcription. So that'd be part of what your judge is going to rule, that this fee was not paid to get the actual recording transcript, but the judge is going to notate that in there. And that is also a judge's decision too. If you go, okay, well, the bill's $500, judge, this was sent to the defendant. Here's, if it's done through the mail, again, certified mail, everything. Here's the signature, that he was aware of the bill, and when the bill needed to be paid, it was not paid. There's no audio recording. That's a judge to put that notated in the file. Not anything you need to worry about. You just need to make your judge aware of what was not paid and received, in order to have all of the records to send over to the new to the higher court. And then the judge would make that in part of the letter that you would send over to that higher court. I don't know if anybody has any questions. I'm sorry, I can't see the chat. So so this is a court of record checklist. And so this is what, and I'll be honest with you, this is my instruction sheets. So I took this, I downloaded it, converted it over into a Word document, and I made a checklist. And this is what you're seeing on your screen, and which is on, like I said, it's in the TMCA bench book. This is what I'm giving the defendants, and I give the attorneys, so they're fully aware of everything that needs to be in there. It says what my role, it tells you what you're going to do. The clerk's going to make a note of the copies of the notice of the appeal, the certification of the defendant. You're going to, send a copy over to the appellate court. And then basically at that point, once you send everything over, then your role's done. Now you're just waiting for that decision to come back. And so before you send your record, even up to the judge, I would sit and go through my checklist. Even for non-records, it really doesn't, I mean, you want to make sure you have all your records. So just go down through the checklist. Okay, the notice was sent here, and my notice has my little checklist. It's going to have the dates. It was sent on this date. It was it was sent and it was received on this date. And I kind of just goes down by step. That's what I do to present it all to the judge, for her to review it, and then decide, yes, the record's ready to go, and take it from there. So the defendant has to pay. So don't forget, the defendant pays the actual cost for the transcript. It's not anything that our court's responsible for. So they have to pay that. So if that bond's going to be defective, if they haven't paid it, they don't have they didn't pay for the transcript, that's the judge is going to approve that record, make the notations on it, and then you, the clerk, you are putting it all together, and you're sending it over to your county court. Now, at that point, that's where like I get everything together. I mean, like I said, right now we're non-record, so I put all my records together. I give that to my prosecutor. And I have my prosecutor take that all over and file it at the county court. I don't know how many appeals that you guys maybe have to handle, but so far I've only, for the non-record, I've done 4. And all 4 of those, just because of the different transitions in the county, and COVID was great and everybody kind of went away, new people came back and all that fun stuff, still feeling the effects of that. So whoever gets that paperwork, that appeal paperwork in the county court, sometimes they don't know what they're supposed to do with it. And so at that point, that's why I give it to my prosecutor, because I have my prosecutor go and he goes to whichever clerk he needs to go to at that time. He'll go to them and he'll explain what this is, and he'll get a file stamp copy that they received the whole record, and he will bring that back to me, and I will scan that and add that to my copy of the file that was sent. So that way we know which clerk received the documentation, when they received it. And so that way that gives me the information. That's my contact person. If it goes 30 days from now and I still haven't received anything or heard anything, I have my clerk that took those documents from my prosecutor. And I have found that that has probably been the only way that we need to function, because sometimes it'll go and it'll sit. Or, sorry if you can hear the big trucks. Or if the clerk there gives it to a prosecutor to review, sometimes it's left on their desk. And so that way, that county clerk, you have a contact person, and and you have a document stamp, because they can give you a record number. They can give a file number. And that file number is the way for us to track down our paperwork. Because I had an appeal one time sit over there for, it was almost 4 months. And it's only because the clerk didn't know what to do with it. So she just left it. And I had attorney, and I had the appeal bond was paid, and the attorney's calling, and all I can say is, well, it was sent up. I don't know. It went to the DA's office. I don't know where it's at. You have to call them. They have all that stuff. But I didn't have a contact person. And so I had learned from that my attorney, my city attorney is always going to get a file stamp. He's going to get a clerk that he gave it to and a file number. We've kind of made that our process. So, so if within your court, if your county court is only like 1 or 2 clerks, maybe that wouldn't be such a problem, but it's always a good, a relationship builder if you or your prosecutor, you take your checklist and go, look, this is, if anybody appeals anything in our court, we're going to send this over. This is what we're having them include. This is how we're presenting it to you. Is there a certain person that's going to be entering this, and which judge is reviewing this? Do all the appeals go to Judge Smith, or is Judge Smith, Judge Harrison, Judge Thomas, do they just like randomly pick who's going to do that? And ask those questions. So that way, which you might find out, okay, it's only this judge is handling any appeals out of that court. And so that way it makes, any questions that come out or any problems arise, which judge it is, and you can contact that judge's clerk and see if you can get answers, especially, if maybe they upheld your conviction, and they were just remanded back to your court to collect money. If you're if you haven't collected, and they're going to collect that money, but you're missing the paperwork that from the judge is saying, yeah, I affirm this. I agree with the verdict. Well, maybe you're missing a piece of paper, but you have a contact. And also, if they say no, the higher court reviews and is like, no, we don't agree with the verdict. We're going to enter the not, that they're not guilty, and send back their appeal. Well, that is one part of like that appeal bond money. That is a part where that truly gets forgotten to be sent back. And so you then have an angry person that paid, whether they paid 50, 100, or they paid 400 and 600, you know, whatever they had to set for that appeal bond. Now, you now are the person trying to track down that money because they're in your court because they gave you the money. And that's all, for most defendants, that's all they remember is that you're the clerk that they gave the money to, so you have their money. And so, not that it's your job, but it does become your job. You need to make sure that you get the appeal bond money back. Or I ask for the clerk to send, their finance department will send us it's like a screenshot of the check, like the check was received, and then whatever the payment was, and they send a screenshot, and I have that for the file too. So they started, there's a new clerk over there, and she's really great about it. So she'll send a screenshot when they actually receipt in that appeal bond. So that's always nice to have too. I think, okay, yeah, I'm still good on time. So this is just a quick summary on it. So for your non-records, so it's a brand new trial. So it's a start over. You send the court documents and you're going to wait. You have 10 days. Sending and delivering is what I give before I reach out to the county clerk and just kind of see what's going on. After the court date, contact the county clerk for any orders. So if they give you a date on this date, Judge Smith will be hearing that case. Notate that in the file, note that however you want to remember it, and then contact, I give it a day just in case the clerk has to scan stuff in or, whatever that may be. I call the next day to find out what happened with that scheduled court date. Do you have to? No, but I like to because sometimes, it's just good to know. And maybe, I don't know, maybe that's just being nosy. I don't know. I just like to know where the case stands after the trial. So that way I can somewhat plan for what may or may not be happening after that. If they were found not guilty and they don't have to pay, but maybe they posted a cash bond when they got out of jail or whatever, then I need to know that I need to get that stuff refunded out. Whatever the orders were put in after that bench or jury trial, whatever the judge ordered them to do. And if mine was contingent on waiting for the decision, like if it's an alcohol charge, okay, well, they might have been found guilty, but they're not going to start doing their community service or their alcohol awareness course until after that case has been heard. They're not going to be doing it while the case is being reviewed. They're going to do that after that judgment is either upheld, or, they were found not guilty, whatever that ruling comes out. So those are things like, that's the reason I want to know what happened. So that way I can kind of plan for what I'm going to need to tell the defendant or tell somebody's attorney. Your court of record, they're going to perfect that appeal. It's going to be all in writing. The hearing, when they do the appeal, it can be heard orally. So their court of record, they can go in and they can argue their case. It doesn't necessarily have to all be in writing. It can be a hearing. They can request to have that hearing. The exception is if they're in jail. Obviously they're not going to have their day in court in jail. Motion for the new trial, your clerk's record, your reporter's record, all the pays and transcription fees are all going to be in there. After you get all it's a very simple little checklist. It's your case file, everything that you've been scanning in. You've got it all, you've put it all together. Everything's been paid. And now the easiest thing, you just hand it to your judge. Judge is going to approve everything that you have and what you're going to send over. That is it. Then you're going to create that bill of exceptions and then you send the record. Like I said, it's not a hard it's not a hard process. I think for a lot of us, because it's not something we do every day, like driver safety or deferral, that we look at it like this is like this is such a confusing process. But really, this is, like I said, when I started kind of looking at it, and I was like, I think I'm right there with a lot of us. I'm overthinking everything that I'm doing. Like, I am trying to make my process so much harder than what it really is, because now all I'm doing is going, okay, well, now everything that you, the judge and the prosecutor have done, somebody else is going to review it. And all I'm doing is just getting together all your work. And now I'm sending it over to somebody else to decide, were you good or are you bad? And so when I started looking at it, I was like, oh, I just need to kind of look at it like that and won't be stressed out about it. And so, so if you kind of look at it like that, it kind of makes, when they say I'm going to appeal, instead of going, oh, okay, what I need to do. Well, you've already, you got your instruction sheets that you're going to give to your defendant. You already know what your judge is going to do. If they have a standard rule, hey, we're just going to do $50 or we're just going to do 100. Great. You know what your appeal bond's going to look like. And maybe you already you can get your forms in. If it's just only $50, well, $50 is the number that's on your appeal paperwork that you're going to give the defendant. So you can just make a bunch of generic appeal bonds with you if you want, and then just the blank lines. And so that's in your trial packet, that's in your bench trial packet, that you as the clerk are going to take with you that day, the day when you start having your trials. And I literally have expandable folder, the old school. I mean, I have blank copies of just blank plea forms, blank judgments, an address update, trial settings, options, and then copies of the appeal bonds, the cash, the surety, and a PR. And they're blank, so that you're gonna write them in. Or if you want to just sit there and do it in your court and you're allowed, go for it and do it. I just kind of take those all with me. So they're all just sitting there. And then that checklist that we have created for a defendant or the attorney's defendant, saying this is what we need if you're going to appeal. Here's your checklist. You need to go 1, 2, 3, and you need to submit all these items. So if 4 is missing, then you can notate that on there for the judge and go, this was not sent. Okay. Then the judge kind of knows. And then from there, they approve everything. And then you're just the mail carrier at that point. So it kind of makes it nice. So I went to, and I did the answers. Is there any questions, or do I need to stop? Does anybody need a break? I guess I've been rambling on for a good hour. Does anybody want to take a 10-minute break? Or I don't mind. You want to take a 10-minute break? Okay. Zeta, can we do a 10-minute break? Okay. All right, great.
Thank you.
All righty. Oh man, well, that'll give me time to figure this out. Data, I can't see if everybody's back. Is everybody back? Okay, all right, well, then I'll go.
I think we're
Yeah.
missing Suzanne, but oh, and Christy. We're missing two.
Okay, all right,
Oh,
we'll just,
Christy's here.
okay. I don't know if it's been 10 minutes or not. Okay, all right.
We're all back.
Okay, well then, I'm gonna go ahead and finish this up. I will just tell you, I will have to hop off here in a little bit because I only have my room for a little while longer. But so one of the questions, I was teaching this in Dallas, and one of the questions, that was asked was, you know, what about the decisions and you know, like what do we have to do once we send it? So I kind of thought, well, maybe I should add that part in there. Because now we're just waiting on a record to come back. And like I said, what's a good time frame? I mean, I don't know. I mean, I would say if 30 days you don't have a response, I think it's you definitely have to call and you definitely have to figure out where your case is at. But usually, like I said, make that contact with your appellate court and see who's handling that, what judge, and that way, you can get court dates or who's going to review it and stuff. So you're basically waiting for the writ for the appellate court to tell you what they decided on the case. It's applicable to the court of record because that's their trial that they had. That's their records that they have. For the court of non-record, it is important and it's not, because once we send that up for the non-record, once we send that up, if it's a jurisdiction, I mean, we're going to kick that back on the appeal bond. If they're going to say the appeal bond, the time has passed. Like if they don't send that in, and they don't accept that appeal, they're just going to send it back to us and it's just going to stay where it's at. But for the decisions and as far as the money and everything like that, that's where we kind of just need to understand what those decisions mean. So, and I didn't add it, and I was sitting here while I was looking at it. I didn't add that, and I was kind of thinking, well, I probably maybe should add that in there. So I broke down the decisions a little bit. They affirm the judgment. That means, fine court costs are imposed, they can stay. And they believe that whatever happened in the court, that's staying in the court. That's what they're saying. Yes, it worked. Now, for a court of non-record, so they get that whole new trial, and it's sent over to the county court. And so if they're convicted so for your trial de novo, for your courts of non-record, if the appellate court finds them guilty, the defendant themselves will pay the county court the fine and the court cost. And that's it. The case is done. So that's kind of where it's nice to know what happened, what was the decision in that for your non-record courts. Because if they were found guilty and they paid it, okay, then they were found guilty and they paid it. Your case is your case is done. It's closed. You're not going to get your money. So that judgment, that response, that's what's needed. So you can give that to your judge. They need to understand, okay, they did get a new trial and they were convicted in the other court, and judgment was assessed and everything is paid there in the county. So you're not going to go after them for the unpaid amount. That's for your non-record, because they're getting the whole new trial. And that's exactly what we need to remember. It's a whole new trial. So what happened in the court stays in the court. That's where they affirm that judgment. If it's a reverse and remand, that's going to be for a new trial. That means they're reversing it and they want it to be set for a new trial. And so there's your statute, and it's going to be held in your court if they reverse and remand it and say, no, new trial needs to happen. Or reverse and dismiss the case is dismissed. Reform and correct the judgment. So your higher court, they want you to modify or correct the judgment. And they give a time frame. It's usually 30 days after that judgment has been entered. And so all of those decisions are only decisions that you as the clerk need to get the response from the higher court. At that point, that is everything that you're giving to your judge. If your prosecutor's involved and they want to know the answers, well, they obviously will if they have to do a new trial. But these are all you're doing is now getting that paper and you're giving those instructions, those decisions to your judge, and then your judge is putting those orders in. So as a clerk, it's pretty simple. Now we're just collecting the papers back that we sent over, and we're giving those back to our judge and going, okay, here's the decision on the case. And then those orders will be given then from the judge. So, I mean, oh, I'm sorry. Zeta, were you saying anything? So these are, so the bench book, your level 1s and 2, the charts, and then I get with other courts. So these are the references that I took, I'm putting this together. So the bench book, I can't rely on that enough, for the step-by-step. And then the TMCA or TMCEC is the level 1 and level 2. They really give some great checklists for us clerks, to go through. The charts I use, when I say the chart, I'm talking about the new chart, which they took the 45 and the 45A and they gave us all the new statute numbers. I have input, gone back and changed those. And then I call other courts, and I ask them, especially in the nearby area, I'll ask them, hey, what do you see happening, or what do you do at this? And I do some good networking and asking other people, other courts, hey, what are you doing and stuff like that, and help on it. And it does, so that's kind of where I kind of got most of this information. Also is what other clerks were doing. So, when you get those responses back for your court of records and stuff, I mean, they're pretty, they'll give you the instructions. If it's the reverse remand, that's going to be your new trial. So, get with your judge, or is there, how soon does that trial need to be? So if you get that back, is it a different trial date? Do you want to have a special date for any kind of appeal decisions? You need to really find out how your judge wants to handle any of those decisions that come back. Now, if it's a reverse and dismiss the case, so that $25 fee, and that's why I was kind of going through and I thought I should probably put that in there under the dismiss part. On a reverse and dismiss the case, that $25 that they paid, that transcription, that's a transcription fee, which they paid for us to get all of our documents together, so that not to get the trial record dictated and printed up. Not that, it's the $25 fee that they pay us just to get the paperwork together to send over. That $25 that will get refunded back to the defendant. So when you're doing your fees and stuff, that $25 would be a fee that you would have to adopt. So if you're working in your budget year, and you go through like your fee schedule and stuff, I know some people like the warrant fees, that type of stuff, that $25 fee, you need to make sure that that's in there, that is a fee that your court's going to collect, that your city will have those funds. But that $25 does have to be refunded back. So that might be a fee. It depends. That'll be a fee that you're going to have to collect. So you need to find out from your finance, is that $25? Is that something that you're gonna lock in a safe, or you're taking the $25, it's gonna go to a special account that is gonna sit there? You know, however that $25 needs to be notated in there, but if it is a reverse and dismiss, that $25 has to be refunded back. And that being said, you're refunding a fee back. Does your judge want to put a standing order on appeals? You know, if it comes back reverse and dismiss, that the $25 is automatically going to be refunded back? Or does your judge want to put the order in, refund the $25 and do it on a case by case basis? So that's kind of a question you kind of need to ask, and then double check that $25 is on your fee list. I have a list of fees, so that $25, whatever you want to call it, if you want to call it, you know, record preparation, transcript fee, you know, whatever whatever it's gonna be worded, that you're gonna remember that, okay, that $25 fee, I'm gonna assess that it's on the case itself. And then that has the potential to be refunded back. So don't forget about that $25 fee on the reverse and dismiss. Reverse and dismiss case. Now, if it's reversed and the new trial, we're not refunding the $25. So that still does stay in your court. And I think that was pretty much, I think that was everything. I was trying, like I said, I took my checklist, went off, double checked my books that are all out there for that. If anybody would like a copy of the presentation, if you like any copies of the checklist that I kind of already did, they're in a Word document, I'll be more than happy to send that to you, so that you have it. I would love for you guys to critique me. So if you guys, you courts of record, if you think I need to add some, I'd love to hear it. Same thing for non-records. I'm open to be critiqued. So whatever you think is missing, or I needed to find more, I would love to hear it. Like I said, I have to present this in 2 weeks, and I wanted to put it in a format that you could just print it out and go by step for it. And I was trying to work it that way. So if you can send me any kind of comments, good or bad, I'm tough. I can take it. And I will gladly you know, make those corrections and stuff, and then share them with you. So but is there anything else, anything I can help you with? Any questions? I guess, does anybody have any questions or any input, like they've had to do appeal and they've had this or that happen? I'd love to hear if anybody had any horrible county thing. My county thing was we had COVID. One lady that did it for like the dawn of time, and then she just decided to retire. Then they brought in another lady and she thought it was too much work, and then she left. And I just kept having appeals just like sit on people's desks. And then so I was like, so I had to create like a gateway over to the county court to make sure that my files didn't get lost. And I actually found, one judge actually said, he goes, I hate dealing with your stuff. He goes, I just hate it. It's a waste of time. And I was like, oh, well, sorry. I'm sorry, people have rights, but yeah, so I got his opinion. So I always hope that my appeal didn't sit in his court, because I think that was one of those things that's your pal of, I'll do it when I want to do it because I don't like to do it kind of thing. You know, it's like cleaning a bathroom. It's like, yeah, I don't want to do it. So, but that's all I have. I'm gonna try and get checked out, unless I mean, you guys more welcome. Zeta, you can take over. The vacuum lady's hitting my door, so I think that means she wants me out. So I'm like,
Yeah,
okay.
no worries. You go get checked out.
Okay, well, you guys all have a good day. Happy Mother's Day to everybody that's a mom or
Thank
grandma
you.
or auntie or what all that. And so have a great weekend.
Thank you. You too.
All right, thank you. Hey, I hope I see you guys if I don't see you again in another Zoom, the court clerks conference. I hope you guys can come. and do that. It's a great networking. It's going to be a high school theme. It's going to be fun. So, cheerleading, football, pep rally type thing. So it'll be a lot of